Now to an update on Oregon Measure 114. You are not voting on that one this time around. Oregonians barely passed it back in 2022 with 50.7% of the yes vote. But the law has never actually taken effect, and it remains on hold right now thanks to a series of court challenges. This week, arguments to try and revive the law were presented to a panel of judges at the Oregon Court of Appeals. But before we get too far into those arguments, some background on what 114 would do. It states that a gun's magazine cannot hold more than 10 rounds. It requires a permit to buy a gun and a safety class to get that permit. It also keeps the gun from being given to a buyer until after a background check is finished. Currently, there's no limit on the size of magazines, no permit required to purchase, and the gun can be given to a buyer after just 3 business days, even if that background check is not yet done. Now, the month after the law passed, December of 2022, 2 gun owners in Harney County out in eastern Oregon filed a suit to block it. And it worked. It's been on hold ever since. Last year, a Harney County judge ruled that the part of the law that limits how many rounds can be held in the gun's magazine and that requirement to get a permit for purchase, both of those violated Oregon's Constitution, which protects the right to own guns. The state appealed that ruling, which is how the attorneys ended up standing in front of that 3-judge panel from the Oregon Court of Appeals earlier this week. Now, as I take you through some of the testimony, we're going to learn a couple of new legal terms. Won't that be fun? Something to impress your neighbors with. The first term we're going to learn is facial challenge. Now, it has nothing to do with someone's face. It's a legal term describing how a law is being challenged. Lawyers can argue that the law is unconstitutional when applied to a specific set of facts. That's called an as-applied challenge. A facial challenge is broader. It means the party is arguing the law is always unconstitutional on its face when applied to any set of specific facts. I tell you that because we're about to hear the state's lawyer argue the people who do not want Measure 114 to take effect, those people are making a facial challenge, which the U.S. Supreme Court has said is more difficult to win. Okay, one last thing. You're going to see a countdown clock on the screen here. Each lawyer gets 15 minutes to argue their case, and the judges can interrupt, by the way. The state is holding back 5 minutes for rebuttal, so they're going to start with just 10 minutes. Here we go with the lawyer from the state arguing Measure 114 is constitutional and should be allowed to take effect.
It's important to emphasize at the outset that this is a facial challenge to the constitutionality of ballot Measure 114. Plaintiffs thus bear the heavy burden to show that the law cannot be constitutionally applied in any scenario. Plaintiffs have failed to do so. That's because under the law, Oregonians remain free to use magazines with a capacity of 10 or fewer rounds. Anyone with a permit can initiate a firearm transfer, and anyone whose background check has cleared is free to complete their firearm transfer.
Oh, how about that? He's going for the knockout punch right off the top there. But the other side does get to make their argument as well, which brings us to the second legal term that we're going to learn tonight, de novo. That's a Latin phrase that means from the beginning or anew. If the Court of Appeals decides to look at this case de novo, it means they're going to examine the entire thing as if the first court never heard the case and as if the trial court never existed. Otherwise, they would be restricted to just looking at what the first court did and if that judge made any mistakes. In this next clip, we'll hear from the attorney for the gun owners. He argues this case should not be looked at de novo, that it should only be reviewed to see if there were factual errors by the judge. That would make it a lot easier to keep the Harney County judge's ruling from being overturned. Judge Christina Hellman is going to challenge him on that. Here we go.
The first is that defendants assert that this case only calls for conclusions of law. Article 1, Section 27, the constitutional provision at issue, and the Christian case, which is the test at issue, require findings of facts. For instance, whether an arm is protected or not is an inherently fact-based inquiry, as is whether a law furthers public safety and whether the law infringes or unduly burdens upon the right to keep and bear arms.
So what do you think our standard of review is?
Your standard of review, as the Muzzy case says, is where there's issues of fact, where the trial court found findings of fact. The issue is any evidence on the record. Where there are conclusions of law, especially the application of law to fact, in those instances, the review is for legal error.
What do we do with the fact that this case is seeking declaratory relief in the form of an injunction And that if a declaratory relief action sounds in equity, we often take de novo review.
The court is not required to take de novo review. Defendants, appellants in this case did not request it. Also, the factors from the Oregon Rules of Appellate Procedure counsel against de novo review in this instance.
So pretty fascinating, huh? All kinds of legal jargon there. But that's basically the opening round as the two sides are jockeying for position and argue how the appellate court panel should even consider the case that's before them. Can they look at it as if it's the first time it's ever been in court? Or are they restricted to just looking at what the Harney County judge did and checking to see if there's a factual error there? And is the argument that the law is unconstitutional all the time or just under certain circumstances? We don't know what the three-judge panel is thinking about on those questions, but their decision will have a huge influence on how all of this turns out. Now, a bit later in the arguments, we heard the state's lawyer explaining to the judges why Measure 114's restrictions on the size of the magazine is not unconstitutional. And believe it or not, this one requires us to travel back in time, back to the 1850s, as Oregon was approaching statehood.
In the 1850s, the capacity of a firearm was limited by its dimensionality. Because of the technology that existed at the time, the size of a firearm limited how many rounds it could fire. And the most at the time that was in common use for self-defense were pepperbox pistols and Colt revolvers, which had a capacity between 4 and 8 rounds. And in Oregon, we were at the end of the nation's supply chain at the time. The most commonly used weapon for self-defense was a single-shot flintlock rifle. Contrast that with a modern-day large-capacity magazine, which only evolved because of 3 separate technological innovations in the 1880s, 2 of them for military purposes. And as this court made clear in Oregon State Shooting Association, military developments that came out after the time of statehood don't qualify under Article 1, Section 27 because it's not personal self-defense. And to contrast the two, you look at to reload, even if you had a Colt revolver or a pepperbox pistol with 4 to 8 rounds in 1859, it would take minutes to reload because you individually had to load primer, propellant, and projectile into each barrel or chamber. To contrast that, I point this court to Las Vegas, the Route 91 Music Festival. A single shooter shot more than 1,000 rounds into a crowd of concertgoers in the span of 11 minutes. In one 60-second span, he shot 298 rounds, ultimately killing 58 and injuring more than 800. Those are very distinct technologies, and military-type weaponry, like a modern-day large-capacity magazine, does not qualify for constitutional protection.
All right, strong argument, but on the other side, the lawyer representing the gun owners argued that the requirement that they get a permit and go through a second background check alongside the federal background check that's already happened, well, that's unconstitutional because it includes everybody.
In this case, the law is not aimed at any dangerous practice.
Well,
it's not aimed at any dangerous.
Isn't it, though? I mean, isn't the idea of the permit and the completion of the check, the goal is to make sure that people who shouldn't have firearms don't have them? Am I wrong on that?
So insofar as, the legislature, the Supreme Court has put a really narrow scope around who you're able to restrict, who the government is allowed to restrict from accessing firearms.
Right.
And those are certain people
Right.
who have been designated as dangerous, a dangerous person in this instance. So a dangerous practice or person must be regulated. And then the state does not have to carry that burden. They have not done so in this case. There's nothing in ballot measure 114 that is unique to people who have been convicted of felonies or have mental health issues or anything like that. It's aimed at all Oregonians. So for instance, a law that prohibits felons from accessing firearms, that's okay because the legislature has designated a certain class of persons as inherently dangerous.
But isn't the purpose of the inquiry, the background check that's done to figure out who those folks are so that they're not given the permit to purchase?
Yes, so we already have background checks at the point of sale in the state of Oregon and in all 50 states in the United States. It's actually federal law that you have to go through a background check. This is a second background check. Prophylaxis upon prophylaxis. It's unnecessary. It's identical in all ways except for the FBI fingerprint background check. And so, yes, we already have background checks in the state of Oregon, and the permit to purchase, its primary aim is not a background check that's already accomplished. It's about requiring all Oregonians to go through some kind of training in order to access firearms. And there's no Supreme Court case law or other case law that gives the legislature or here the people the authority to designate all Oregonians as inherently dangerous persons unless or until they disprove that by going through some kind of training. Basically, you're presumed guilty or unfit until you prove otherwise to the government.
Okay, another strong argument. Now, Measure 114 continues to be on hold and probably will be even after the Court of Appeal rules. You can bet it will next go to the state Supreme Court. And at the same time, another challenge in federal court is making its way through that system. A federal judge in Portland ruled the law does not violate the U.S. Constitution, but that case also is expected eventually to make its way to the U.S. Supreme Court. So it's not the last you've heard of Measure 114. We likely have months, if not years, of litigation left before we get a final answer on this.